Florida Association of Broadcasters and this station.
Strength Between Sundays. Faith Talk 570 and 910. Online at letstalkfaith.com. The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Oh, hi there. Happy Saturday morning. I'm your host, Attorney Patrick Smith, and you're listening to the Attorney Patrick Smith Show. We're with you every Saturday morning to answer your legal questions. If you have a question this morning, the law office is open, 877-943-9673, 877-943-9673. You can call in now. You can email your question, Patrick at attorneypatricksmith.com, Patrick at attorneypatricksmith.com. So we're here every Saturday morning just to help you feel a little bit better about different legal matters that came up during your week, and that's the sole purpose of the show, just here to help you. So if you have a legal issue that arose during your week and you have a question about it and you would feel better, you can call in now. We're live and local, and you can call toll-free phone line. Open phone lines will get you right on the air, you and your question. A lot of times the first caller sort of sets the theme for the show, so you can be that caller today. 877-943-9673. We'll see if we can get our Sun City Center listeners fired up. Those listening on 96.3 Sun Radio out of Sun City Center, Florida. Maybe someone from Sun City can be our first caller today. 877-943-9673. Nevertheless, if you want to be part of the show, that's how you participate. You call in with your question, and you and the rest of the listening audience all benefit from the answer. So 877-943-9673. You can email your question to Patrick at attorneypatricksmith.com. For those of you who don't know me or are new to the show, I'm local Central Florida attorney Patrick Smith, and I've been in practice over 15 years now. I primarily do wills, trust, probate, trust administration, estate planning, that sort of thing. But have practiced in lots of different areas over the years and work with many different attorneys who practice in a variety of fields. So if you have a legal question, I know probably just enough to be dangerous, but remember our promise to you, we can always give you the best answer, and that means sometimes me saying I don't know, and putting you in touch with an attorney who practices more specifically in a particular area, or maybe another type of professional like a CPA or financial advisor. But that's our promise to you here on the Attorney Patrick Smith Show. We will always give you the very best answer we can, even if it means from another professional. So 877-943-9673, 877-943-9673, or email your question, Patrick at attorneypatricksmith.com. All right, let's go to our first caller for the day. Let's go to my home county, Imperial Polk County, and let's go to Haines City and talk to Joyce. Joyce, welcome to the Attorney Patrick Smith Show.
Welcome. Thank you for having me on.
Joyce, happy to do it.
I'm going to be moving, and I was wondering if a good elderly lawyer in Pennsylvania, please, that could help me with some problems I have.
So I actually happen to work with attorneys all over this great nation of ours, and I'm proud to do so. There's a wonderful young lady I've worked with by the name of Stephanie Kalagridis, and she is out of Bryn Mawr, which is right outside of Philly. And if that's near where you're going to be, great. If not, I'm sure Stephanie can point you in the right direction of someone who is closer to your area. And if for some reason Stephanie's not, you can always contact the Pennsylvania State Bar Association, and they will be happy to give you a list as long as your arm of attorneys in your area.
Thank you.
All right. What station are you listening on 90.3 FM?
Yes.
All right. Well, Joyce, thank you for calling in. Thanks for being our first caller of the day, okay?
You didn't give me her phone number.
Oh, I don't have it handy. If you call me at the office on Monday, I will give you Stephanie's number, okay? So just give me a call. I'll give out the office number here in a little bit, and you can call me, and I'll be happy to provide you her number, okay?
Thank you very much.
You're
Have a
welcome,
good
Joyce.
day.
Good luck with your move, okay?
Thank you.
All right, have a great day. Alrighty, this is the Attorney Patrick Smith Show, and the number 877-943-9673, 877-943-9673. That's sort of a unique question to start with. So someone relocating from the state of Florida, that's definitely flowing against the tide. It seems like everyone is moving to Florida at this point, but great question to start with. Sometimes people do relocate. And that often leads to, the most common question we get in the law practice: are my out-of-state wills valid in the state of Florida? And the answer there is yes. If they're valid in the state where they were created, they're valid here, but you may still want to have them reviewed by local counsel to make sure they're optimally efficient, because there can be light years of difference between validity and optimal efficiency. And that's what the review appointment is for, to make sure your residency status is accurate, make sure the documents are self-proving, make sure everything's going to avoid probate effectively, and really optimize your family's inheritance. 877-943-9673, 877-943-9673, open phone lines. You and your call, you're just a phone call away from getting your question right on the air, 877-943-9673. And you can email your question, patrick@attorneypatricksmith.com. You can also reach us at the law office during the week. And as I promised Joyce, let me give out the toll-free number. If you want to reach any of the office locations, you can call us during the week at 877-754-6764. 877-754-6764. And any of the young ladies who answer on the staff will be more than happy to get you scheduled for your complimentary estate planning consultation. We have an office right there in beautiful Haines City, Florida, as well as one in Tampa and Seminole. You can always give us a call, 877-754-6764. We'll be happy to get you scheduled for your consultation. But to be part of today's program, again, 877-943-9673, 877-943-9673, or email your question, patrick@attorneypatricksmith.com. I want to talk to small business owners for a little bit, because this came up at the office this past week, and it was a question that was important enough where I felt like it needed to be addressed on the air, because too many people I've found recently are coming in with their corporate papers, and they've set up a small business, and for some reason they're under this impression that simply registering a fictitious name with the Secretary of State's office through SunBiz is somehow a finish line, where they have successfully crossed into the realm of owning a business, and now they're all set. And that's just the starting line, registering. It's how you maintain that business from that day forward that will ensure the integrity of the business. And what the goal is to preserve the business from something called piercing of the corporate veil, where they're able to actually pierce the LLC or the corporate protective measures you put in place because you haven't properly maintained it. So what do you need to do to properly maintain your business? Well, number one, file your annual reports. Number two, I think it's incredibly important to make sure that you use the business account as a business account, and make sure you're not paying personal expenditures. If you want to get money out for personal use, you take it out through something called a paycheck. You pay yourself, and that's how you make sure to get the money out efficiently. So at the end of the day, it's not just about setting up that business. It's about maintaining it from the date you set it up. And a lot of times people say, well, I didn't file the annual report because nothing happened. That's fine. Your annual report might say nothing more than, we met this date, this time, this location, no action taken, respectfully submitted, secretary of the business. And people often overlook that. And I think it's an incredibly important box to check. And also for those of you out there who are small business owners with a trust, make certain that you have those LLCs appropriately titled to the name of your trust. And furthermore, make sure your trust has the appropriate language to own and operate an LLC. So all those are important topics for you small business owners out there to think about at this time. 877-943-9673, 943-9673. That's your live and local number to be part of today's program. You can email your question, patrick@attorneypatricksmith.com, or give us a call now. Open phone lines, 877-943-9673. All right, let's go to Clearwater and talk to Bob. Bob, welcome to the Attorney Patrick Smith Show.
Good morning. Thanks for being on the air to help us.
Thank you, Bob. I appreciate that.
I don't really know if I have divided the major part of my estate into beneficiaries. Just said that each one is going to get this. They're going to break it up. I busted everything into 7 pieces. Now, that doesn't have to go into a will, does it?
Well, it depends. So it's going to depend on various other factors. So I presume we're talking about financial accounts here, Bob, like checking, savings, brokerage, things like that, annuities, 401ks.
All the financial accounts, 401ks, everything is divided 7 ways.
Yeah.
So,
So your will wouldn't control any of that, presuming that all 7 beneficiaries are living.
Okay, I've done this per stirpes, which I think is if they're not living, the rest of the guys divide up in 6 parts what that person was supposed to get. Is that correct?
No. So if you do the per stirptual language, per stirpes, the literal translation of it's probably a little too graphic for broadcast over the air, but I'll suffice it to say it means down the bloodline. And so what it means is if you said 7 equal shares, 1 through 7, and one dies, one's share now goes to the bloodline descendants of 1, not to the other 6.
Ooh.
Right. So that's something you want to check on, because your thinking is it's going to go to these other 6. And if it's set up, you check that per stirpes box, you've got a problem. The other issue to consider, Bob, what if you don't die right away? What if you're prolonged incapacitated because of a coma from an accident, or God forbid you develop dementia or Alzheimer's? All these accounts are simply payable or transferable on death, and that means death only. So I think you need some good mechanism there to govern and protect the assets during that window of incapacity. You know, the statistics tell us most of us will be incompetent for some period prior to our passing. And
I started that already.
Have that second cup of coffee, Bob, and I promise that'll get a little better. But all kidding aside, it's those final 30 to 90 days of a person's life that are often the most expensive days that they ever live. So having someone that you've selected to captain your family's financials during those window of incapacity period can go a long way to reduce or eliminate a lot of those major expenses.
Hey, thank you. I think I'm covered in that situation. I have a long-term disability policy that will pay out as much as $450 a day. And that should get me a nice room in one of those places looking out at the baseball field so I can watch the games. $450 should take care of me. And I think I'm covered.
Yeah, make sure you have your annual review with your financial advisor. And if it's been a couple of years since you've seen your attorney, make sure you go in just to get a little, check up on those things just to make sure that everything's in place.
You're very helpful. Thank you very, very much.
Bob, I appreciate you calling in. Enjoy Clearwater today, okay?
I will.
All right. This is the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and you can call in now. We're live and local. Open phone lines, 877-943-9673, 877-943-9673. We're here for one thing, and that's to talk to you this morning and help you with your legal matters. Lots of great calls so far to start the show. 877-943-9673. And you can always email your question, patrick@attorneypatricksmith.com. All right, we spoke it into existence, folks. Let's go to Sun City Center and talk to Jim. Jim, welcome to the Attorney Patrick Smith Show.
Yes, thank you. What I'm calling about is I want to know about a will. I have 2 girls. They fight. They don't talk to each other. And I was just wondering how I would go about doing a will so that there'd be like the attorney involved. or an executive involved. That way, they can fight all they want. So I was just wondering if you could give me some advice on it.
Well, Jim, just to back up a moment, when you said you have 2 girls, I presume you mean 2 daughters?
Yeah.
Okay, I just wanted to clarify. I was going to say, if you have 2 girls, like 2 girlfriends, no wonder they fight. I mean, there's a natural common disagreement there. So that makes perfect sense. But 2 daughters, yes. So this happens more often than you realize, Jim, where someone will approach the attorney and say, look, the family doesn't get along for whatever reason. There's animosity between the heirs, or commonly it's a blended family. As people live longer and longer, we see this a lot where, mom and dad are married 50 or 60 years, one of them passes, and then they find someone else to spend the rest of their life with. And that's great, because the deceased spouse probably wouldn't want them to be alone to begin with. And at the end of the day, it's a situation where the family wants to make sure that their wishes are honored, so they pick a neutral party, and maybe it's a brother or sister, someone who's not a beneficiary, or maybe it's a CPA, financial advisor. It can be the attorney. And if we do it, I always make sure to have full disclosure to the client about all the fees associated with any administrative function. It's about 1% when you're serving as trustee on a trust, personal representative on a will. It's presumed reasonable at 3%. So at the end of the day, I always have my clients sign off saying I fully disclosed these facts to them, and that way no one feels like there was a lack of transparency or any sort of hidden ball trick. But that is a great way. When you have battling beneficiaries, you can remove a lot of the battle from the estate by having a neutral party serve as the administrator, Jim.
Oh, I see. Okay, yeah. Because I know, like, I got one girl, she thinks I gave everything to the other girl already, and I haven't given out anything but I want to give them. And I don't know where they get their information, but so they're angry because one says, oh, you gave me everything, Dad, and the other one says, no, you gave everything to that one. So, so that's what I was wondering, because it's going to be a simple will. It's just no furniture or nothing. It's just has to do with bank accounts and that. So it's going to just be a little will. So I was just wondering, do I get an attorney to write it up?
Yeah, we'll be happy to meet with you. We have a Sun City Center office there in the Pant Wealth Management building, and the fee for a will at our office is $75, Jim, so you feel free to give us a call. I'll give out the toll-free number here in a little bit, and I know I'm just glancing ahead at my calendar this week. I know I'm going to be in Sun City on Tuesday, so you give the office a call and see if they can work you in for Tuesday, and we'll do our best to get that will taken care of for you.
Oh, thank you. I appreciate that.
All right. Well, Jim, good luck with your daughters. A lot of times these situations tend to calm down over the years. And remember, it's like they say in politics, perception is reality. So when you say you don't know where they're getting their information from, a lot of times the source is their own brain. So there's no way to fix that. They just have to sort of process through it themselves.
Right. Okay. Thank you.
Jim, thank you. That. Enjoy the rest of your Saturday. All right, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. The number, 877-943-9673. Call in now to be part of our show, 877-943-9673. Toll-free open phone lines. You can email your question, patrick@attorneypatricksmith.com. And let's go to our next caller. I believe we're going to go to Will in Gibsonton. Will, welcome to the Attorney Patrick Smith Show.
Good morning. I have a piece of property that's free of mortgage, and I went through a divorce 3 or 4 years ago, and her name is still on the deed. We had a prenup. I thought it was explained in the prenup, but the title people looked at it and said it's not. I've contacted her to try and get her to sign a power of attorney or a quitclaim deed or whatever. She's not really returning my calls. Do I have any legal? Will I have to take her to court to get her name off, or what can you help me with?
So the short version is, I'm presuming you had an attorney represent you in the divorce?
Oh, I wish I would have.
So it went that well, huh? All right, Will.
Well.
So the short version is, typically, and I don't do family law personally, but I have a wonderful family law attorney that I work with, and I can give you his number at the office on Monday. I'll give out the office number here in a little bit. But the short version is, in a divorce proceeding, typically there's language that says in the divorce decree that, the spouse will be ordered within 30 days of the decree to effectuate a quit claim deed or warranty deed or whatever, transferring the property to the other spouse's name. And then they will say something to the effect of, failure by the spouse to do so will result in this court's decree operating as said deed. So you could record that, and that would be sufficient to remove her name. But going without counsel on this may have been the mistake, because that language may not be in there. I think you need to have someone take a good, long, hard look at that divorce decree and see what language is and is not in there, along with that nuptial agreement you very wisely did. So my family law attorney that I work with, he's of counsel with me, and he will be more than happy to give you a...
Where's his office located?
Well, he's all over. So he takes cases in Pinellas, and you're in Gibsonton, is that right?
Yes, sir.
So he takes cases in Lake and Gibson, or the Pinellas County, Hillsborough County area as well. So I'll give you his number on Monday, and I'll give you the office number here in just a few moments, okay?
Okay, thank you very much.
All right, we'll get you taken care of.
All right, thank you. Bye-bye.
You're welcome. Bye-bye. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. Give us a call now, live and local, open phone line, 877-943-9673, 877-943-9673. Yeah, sometimes divorces happen. You always try to avoid that at all costs. Marital counseling is some kind of hope that you save the marriage, but unfortunately, sometimes it just doesn't work. And when you do go through a divorce, we strongly recommend you involve an attorney just to protect everyone's rights. It's always wise to get a professional. It's like if you're going to go do surgery, you don't try to save a few bucks by doing it yourself. You hire a physician and you go into an OR, you get it done properly. It's too important to risk some mistake like that. So to give us a call at the office during the week, if you have a family law matter or something like that you want to discuss, 877-754-6764, 877-754-6764, and we'll be happy to put you in touch with our of counsel family law attorney. But to be part of today's program, 877-943-9673, or email patrick@attorneypatricksmith.com. All right, next we're going to Port Richey, and we're going to talk to Robert. Robert, welcome to the Attorney Patrick Smith Show.
Again, on the hierarchy of beneficiaries, I have no will, and I have in-laws with children and direct cousins with children. Which would predominate in passing my small bank account?
So, all right, Robert, let me back up a second. So you have some accounts and you don't have any beneficiary designation on them. Is that correct?
Yes.
Okay. And so your question is, who would your heirs at law be? Who would be that sort of priority heir?
Precisely.
Okay. Well, the short answer is I don't know, because it doesn't matter who it is today. It matters who it is on your date of death. So I'm going to give you an answer based on today's facts, but realize it's very subject to change, and then I'll talk about how we solve that problem, okay?
So, the death is imminent.
Well, Robert, I'm sorry to hear that. I mean, I hope you're not at the point where you stop buying green bananas, but I'm sorry to hear that, and I'll say a special prayer for you. The short version is, you said you have no children, correct?
Yes, no immediate family.
So that means no wife, no kids, parents have predeceased you. Do you have any siblings?
Negative.
Okay. Did you ever have any siblings, or are you an only child?
Yes. One brother.
You had one brother. Did your one brother leave any children?
Yes.
They're your beneficiaries. On today's facts, those would be your beneficiaries, the children of your predeceased brother.
Thank you.
And if you want to change that, and if you want to govern against it, you could put together a really simple will, Robert, which, like I said, at our office, it's $75, and you can take all the guessing out of it, where you can say, hey, look, This is who I want it to go to, and if one of these people dies, this is what I want to happen. So you can take all the guesswork out and control for those contingencies. You get to pick the administrator, all those sorts of things, and really make sure your wishes, your will, are truly honored.
Thank you.
You're welcome, Robert.
Another question. Several months ago, I left expired lease, and the landlord was negligent in protecting my belongings as promised. The people that stole the contents are still around, and the landlord doesn't acknowledge any negligence or wrongdoing. What recourse would I have litigation-wise?
Well, number one, if you believe a crime's been committed, you need to report it to the police so that they can investigate.
There was no report
Okay.
at the time.
All right. Did you call the police and attempt to file a report?
No, but
I would do that. If you believe a crime's been committed, file a police report. Number two, I need you to get me a copy of that lease, Robert, because I've got to see and put eyes on what exactly you contracted to tell you what sort of recourse you have in light of that.
Well, the lease was terminated, and I subsequently left.
Yeah, I still think you start with the lease and see if it had any provision in there regarding items that might have been left over after your tenancy terminated, or what it said, if anything. And if it says nothing, then we fill it in with the state code. But I think we start by putting eyes on that lease.
I thank you very much.
Robert, I'll say a special prayer for you, young man, okay?
Okay, bye.
Bye-bye. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. 877-943-9673. Open phone lines. We'll get you and your question right on the air. 877-943-9673. And you can email your question, patrick@attorneypatricksmith.com. And as I promised, that office line, Robert, 877-754-6764. 877-754-6764. Just give us a call at the office during the week. Get us a copy of that lease, Robert, and we'll be happy to take a look at it with you and get some answers and resolution as far as your options on that personal property and the remainder and possible recovery, maybe some sort of action and replevin to recover those items. But to be part of today's program, 877-943-9673 or email patrick@attorneypatricksmith.com. All right, let's go to beautiful Sarasota, Florida, and talk to Joanne. Joanne, welcome to the Attorney Patrick Smith Show.
Good morning.
Good morning.
Thank you. I'm
Yes,
so
ma'am.
happy you are there.
Oh, I appreciate you saying that, Joanne. Thank you.
I'm a long-time listener. I have two questions this morning. One has to do with my will, which I kind of need to redo. My son recently married, and he has this 16-year-old boy. My grandson, my only grandchild. And my concern is, and I did do stirpies in the will, as I understand it, if something, my son predeceases his son, will everything automatically go to my grandson?
Yeah, if you've got it set up per stirptual. Now, again, without looking at the will, I can't verify for sure. But based on what you've said, Joanne, yeah, if it was left to your son, and it says, and my son predeceases me then into his bloodline per stirpes, that would include all of his children. Now, if he only has the one, then yes, it would include that one.
Okay, so if another child comes, I should, redo it. But I don't have a vast estate for sure.
Well, whether or not you'd redo it would depend on whether or not you. That's why most people do the per stirptual language, is to include future born grandbabies, because kids have this nasty habit of growing their families. And
Right.
you don't always know how many kids they're going to have when you pass away. So you do this sort of Latinized contingency plan with issue per stirpes to control for that. But your point is well taken. Maybe you only want to include this particular grandchild. So you have the option of doing it that way, but that's up to Joanne.
Right. The other question, I do have more questions on the will, but I won't, get into that part. But I did have a question regarding a previous caller, and it had to do with corporations and piercing the veil type thing.
Yes, ma'am.
And he has a C Corp. Am I saying that correctly?
Yes.
And I am a stickler for, dotting the I's and crossing the T's and not purchasing things with money that belong to the corporation. Writing checks and paying for something. In other words, how does that work? Because I really feel like he's not being careful.
Yeah, I think at the end of the day, if it's a business expense, it comes out of the business account. I think if it's a personal expense, it comes out of your personal account. Now, sometimes you get stuck in a spot, and maybe for whatever reason you had to use your personal account. I think that's probably okay on rare occasions where you document it as such. And
did you mean to say on rare occasions you use your business account?
Yeah, on rare occasions you use the business account for a personal expense. But where that's documented that, it was done kind of in a pinch for whatever reason, maybe you didn't have the business credit card or maybe the business credit card's in American Express and this particular institution only took Visa or whatever. I think something rare like that's fine. Probably not going to be enough to pierce the veil. But I think where it's this routine sort of, I'm going to Publix every week and buying groceries from the corporate account, I think that's what makes the corporate account vulnerable.
Right. If they do that, as long as they report using the account as a personal purchase, that's okay?
I would still prefer that if they want to use the proceeds in the corporate account for personal expenditures, they remove the money from the account through the payroll process by taking a paycheck and then putting that money in their personal account just to show that they've got that sort of steel curtain between the two and that they're not.
I'm going to recommend that he speak to a financial advisor, as you suggested. And the final question, I have a small IRA left, and I wanted to make my grandson the beneficiary. Now, he is a minor. Would that just go directly to the child, or would the parents step in? What if my son wasn't there, How should I handle that for a minor?
Typically, you would create a trust to hold the IRA proceeds, and you'd put special language in the trust designed to hold the IRA proceeds in light of the tax consequences. And then you would decide the ages and sort of milestones that the grandchild would have to achieve in order to come into the principal of the trust.
Who handles the trust? Who would be a good person to handle the trust?
You get to pick. You can pick any member of your family who you believe would be a qualified trustee. It could be your financial advisor, your CPA, your attorney. It could be anyone you trust to sort of captain your family's financial ship in a world where you've entered eternity.
Yeah. Okay, thank you so much, Patrick.
Joanne, you're most welcome. You enjoy the rest of your day, okay?
God bless you, honey. Bye-bye.
Thank you. All righty, you're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith. The number to be part of our program, 877-943-9673. 877-943-9673. That's your toll-free number. Open phone lines. We'll get you and your question right on the air. And you can email Patrick at attorneypatricksmith.com. Also, I'll say this for the record, too. When it comes to LLCs and corporations and expenditures, I always also bring in a good tax professional. Anytime there's a question, I like to get a good CPA's opinion from the tax side of things. So I will say that, too. If you're out there and you're a small business owner, it's not just your conversations with your attorneys, but it's a conversation between your attorney and your tax preparer as well that I think are going to be critical. Alrighty, next we're going to go to Ron in Lakewood Ranch. Ron, welcome to the Attorney Patrick Smith Show.
Good morning, Patrick. How are you?
I'm great, Ron. How can we help?
Good. Okay, quick question. I'm not sure if I misunderstood you, but the fee that a trustee would get to manage your estate upon death, was that 3%? And if it was 3%, is that of the total value of the estate itself? And does it go on a yearly basis, or is it a one-time charge?
So the number I said for trustee of a trust was actually 1%.
Oh, 1%.
Right. 3% is the personal representative's fee that's suggested reasonable under the statute. It's not binding in any way, but it is suggested to give everybody an idea of what a personal representative should be getting paid for serving as the personal representative on a probatable estate. So it's different on the trust. Now, the actual trust code says something even more ambiguous, Ron. So here's this. Try this for, 8:36 on a Saturday morning. It says any trustee is entitled to a reasonable fee. Now, how's that for being nebulous?
Yeah,
right? And it's not possible that people could disagree over what's reasonable, right?
Yeah.
So I tell people 1% because that's sort of like industry custom. But the reason the statute says that, the public policy behind that, Ron, is there has to be someone to police the trustee and make sure that they're charging an appropriate fee. In other words, they don't just say 1% in the statute. Why? Because 1% could be distortatively low or it could be distortatively high, and I'll demonstrate that for you. So let's say we have two different estates, both worth $1 million. One is a cash account going to one child who's a healthy adult son. The other one's $1 million, but it's made up of 10 pieces of property, and they're scattered all around the world, and it's going to 35 different beneficiaries, some of whom are minors, special needs, some are foreign nationals, some are charities. Now, they're both $1 million estates, but are they both 1% fees? Hardly. That's why the statute says a reasonable fee. But who ultimately blesses the fee as reasonable? Is it the trustee? No, it's the beneficiaries. Because the trustee has a mandatory duty to account to these beneficiaries, to say, look, here's the work that I've done, here's the fee that I'm proposing. And the beneficiaries have 30 days to review, question, or to consent to the fee. If they do object to the fee, it'll go before a judge where the judge will review it and either bless the fee, raise the fee, lower the fee, depending on what the judge finds appropriate. But at the end of the day, it's the beneficiaries who hold the ultimate say over whether or not the trustee's fee was deemed reasonable. But we say 1% because that is sort of industry custom. That gives you an idea of the neighborhood of the reasonable fee.
Right. I understand that. And the reason for the question is this. If you have a sizable estate in several $1 million, you have to, I think, in your own mind, say, should I drag this estate out over a period of years, which you're paying someone to manage, or do you wipe it out immediately, meaning you give what you're going to give in a one-time shot to X, Y, and Z, and end of state, end of the estate. You see what I'm saying? Because I don't know that you want to get put in a position where you're paying so much money out of the estate to have someone manage it. So is that not a fair question to ask, to balance between do you drag it out over, a year, 2, 3, 4, 5 years, or you say, no, I'm going to give whatever I'm going to give to everybody. It's a one-time shot, boom, it's over.
Well, better than a fair question, Ron. I mean, it's the goal. I mean, the goal here in estate planning is not just putting words on the page. It's putting words on the page such that we've achieved something called optimization. We get the most real dollars to your intended family members in the best way possible, as quickly as possible. Now, a situation where a family's normal, healthy adult children, I agree with you. It's an outright distribution. And that's what you want, because that's going to reduce those fees. It's not an ongoing trust. There's no staggered distribution or anything like that. So I couldn't agree more with that. I think that's the goal. Why hemorrhage money for no purpose at all? If you can do an outright, but there are some situations where you can't. So say the kids are 6. I mean, this money's going to have to be managed. There's no way around that. I think it's going to have to be overseen by a trustee. But in a world where you can do that, I think that's the goal. Is you would have an outright distribution. Why have it linger on for no purpose? And I'll say this: a trustee that is specifically dragging their feet just to get extra fees, I think that's wrong. Just to put it in layman's terms, and I think it's probably a breach of a fiduciary duty. There's a fiduciary duty a trustee holds to the beneficiaries called prompt administration, a duty to administer the estate as quickly and efficiently as possible without compromising the integrity of the administration. And I think that dragging it on purposely just to get that extra fee is a breach of that duty. So I don't think that's right. But to your point on the drafting side, when you can, draft for outright distribution. Get as much of that money as quickly to the family members and keep it out of other parties' hands. Absolutely.
All right, Patrick. Food for thought. Thank you very much.
Ron, thank you for calling in. Enjoy Lakewood Ranch.
Okay, thank you.
All righty. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673, 877-943-9673, Patrick at attorneypatricksmith.com with your email questions. About 10 minutes here left in the show. And next we're going to go back to my home county of Imperial Polk County and talk to Jay in Lakeland. Jay, welcome to the Attorney Patrick Smith Show.
Good morning. Thank you for taking my call.
Yeah, Jay, thank you for calling.
The question I have, and I won't go into too much detail, but my mother passed away October of 2020. She did not have a will. There is an estate, a home that still has a mortgage, and I've got two distant sisters. And the way that this was set up with the attorney that I had hired last year to handle this, to put me in charge of handling her affairs, set it up to where obviously everyone is entitled to 33 1/3. She did have a checking account. I did itemized accounting on that in February of this year and made the disbursement to my two sisters. But I've been paying the mortgage, electricity, water, pool, and lawn service for over a year, and I'm currently prepping the house for sale. What my concern is, because of the way that it's set up on the home, how am I going to get reimbursed? And what is your advice as far as getting reimbursed for the expenses that I've put out over the last year on this home? Like I say, my two sisters are distant, and I've taken on the sole responsibility of paying the mortgage and all the other bills.
So all of that was extremely important, Jay, but the most important thing you said to me was the attorney that I hired. So that tells me you're represented by counsel. So there's very strict rules about what I can do in light of that. So here's my advice to you. You've got an attorney. Take exactly what you just said to me and put it in writing to your attorney.
I do not have an attorney.
Oh, you do not have an attorney?
No, I had hired an attorney last year just to set it up to where I was able to handle her affairs, and I'm not currently representing. So I was going to email you about that also.
That's fine. So in that case, if you're without counsel this time, I'll give out the 800 number. We can meet you there in Polk County, and there's a protocol by which you can petition to get reimbursed those expenditures that you're out of pocket.
That's perfect.
Yep. So yeah, Jay, it's a simpler solution than you think, and it may or may not. It's going to depend. So you don't necessarily need the consent of the other parties, but what you do need is a lack of objection by the other parties. But I'll give out that 800 number here, and we can schedule a time to meet in person. I can review what you have in the file, and we can sort of walk you through the steps and give you a quote for those services and go from there.
That's perfect. Thank you very much.
Thank you, Jay.
I'll be in touch.
I'll look forward to it. Enjoy Polk County, okay?
Yes, sir.
All righty. You're listening to the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, 877-943-9673, 877-943-9673, Patrick at attorneypatricksmith.com. That toll-free number to call me at the office during the week, by the way, if you want to meet us in the Haines City office, Sun City Center office, Seminole, Tampa, any of those offices, 877-754-6764, 877-754-6764. That's our toll-free number at the office. Alrighty, let's go to Roger in Largo. Roger, welcome to the Attorney Patrick Smith Show.
Good morning.
Good morning, Roger.
I have a question concerning the fact that my brother and I are having a disagreement over I-bonds. My father had purchased some I-bonds, and the beneficiary was my mother-in-law, and she passed away suddenly. And the I-bonds were in a safety deposit box with my brother's name on that box. He contends that they're his, but since it's her my mother was the beneficiary, then I believe that it's part of the estate. I was just wondering who was correct on that.
So just to make sure I understand the facts, your father passed away.
Yes.
And then your stepmother passed away after your father?
Well, it was my mother passed away after my father passed away. And
Okay.
she was the beneficiary, or is the beneficiary on those I-bonds. They were not cashed in.
So technically that means that Dad left it to Mom. Mom passed, but Mom passed after Dad, so her rights to those bonds vested. That's the legal term. She owned those bonds, whether or not she went through the legal protocol for it. And that means that, did Mom have a will?
Yes, she did.
So whatever Mom's will says, Roger, that's what's going to happen to those bonds. It doesn't matter that they were in a safe deposit box in Brother's name. Now, if it was personal property, like gold coins or jewelry, I think he has a better argument. But let's change it from bonds to like a deed on a house. And if it was a deed on the house that had Mom and Dad's name on it, and they had both died, and the deed was simply in a safe deposit box in your brother's name, he says, well, that means the property's mine. That argument carries about as much water as the argument he's making regarding the bonds. You go by the words on the page with something like that. So I think that the proper administration there is Dad left them to Mom, Mom's rights vested, Mom's will controls what happens to those bonds post-mortem. So I don't think it's a matter of where the bond was physically located.
Okay, well, that's exactly what I wanted to know. Thank you so much.
Roger, thanks for calling in. Alrighty, this is the Attorney Patrick Smith Show, 877-943-9673, 877-943-9673, Patrick at attorneypatricksmith.com for your email questions. Let's go to Sarasota and talk to Tony. Tony, welcome to the Attorney Patrick Smith Show.
Patrick, welcome to WTBN. I listened to Joe Pippin for many years. You're doing a fantastic job of not missing a beat, and you're filling those shoes nicely. I just want to say thank you for what you're doing. I always considered this type of a show a public service. You don't know how many people appreciate you being on, and you sound like the type of a guy that a person can trust because, to be honest, most of us are terrified of the law, lawyers, and getting involved in court. So thank you for being there, and thank you for being a man of integrity.
Well, Tony, you ruined it, and I thought this was going to be the first show that I got through without getting at all emotional about Joe, and I can't tell you how much I really appreciate your kind words. So, Tony, thank you for saying that. It means the world to me, and you have no idea how much I treasure you saying that. Thank you.
God bless you. And I have a complicated situation. I'll make it quick.
Yes, sir.
I've been taking care of my mom. She's in her 90s. She has advanced dementia 24/7 for a little over 2 years. And we thought that hospice would be a good idea. Wait till you hear this one. So the hospice people come to the house. They certify her as being hospice worthy. Now, we had Medicare, United Health, all that stuff, which was kind of a good thing, but also a nightmare because dealing with United Health can be a nightmare. Mm-hmm. And we had a $6,700 threshold a year, and then after that they pay for everything, supposedly. So the day of hospice, she's okay. The very next day, before they started coming to the house, she passed out twice, had to go. We didn't have hospice to really, do anything. They didn't get incorporated into my home yet. So we sent her to the hospital. They did their thing for 3 days, and now she's in a facility where they take care of her for 20 days, and then she's going to wind up coming back home because they strengthen her. They get her back up to normal, thank God, because she has all kinds of medical things going on. So all of a sudden I'm getting bills now saying that, for x-rays and for this and for that, which is going into thousands of dollars, that she's being rejected from United Health to be paid. And I'm like, what?
Well,
I'm like,
hey, Tony, I'm sorry to cut you off. I'm going to run out of time. So do you mind holding the line, and I'll talk to you off the air because I can already tell it's going to take more time than the 90 seconds I have left.
Thank you so much. I'll be right here.
Just hold the line, Tony, and I'll talk to you off the air. There's one other call I got to squeeze in. All right, let's go to Peter the intern. Peter the intern.
Hey, Patrick.
Why aren't you here,
How
Peter?
are you doing this morning?
You're not in studio. Where are you, Peter the intern?
I am in Indian Rock Beach for a little festival they're holding at Cole Park off of 16th Ave. We've got a tent set up with business cards and placards, and I'm going to be here, and you're going to be here answering questions and hopefully helping people get their trust done.
That's right. So, guys, right after this, I'm going to be answering a couple questions off the air, and then I'm headed straight to Cole Park in beautiful Indian Rocks Beach, my hometown now. where I live with my wife and son. My soon-to-be, as of this Tuesday, my 16-year-old son. So we will be there, Cold Park, for a family-friendly Oktoberfest all day today. So feel free to swing by there, 16th Ave. Peter, the intern, thank you so much for setting up the booth. I'll see you shortly, buddy.
All right.
All right. All righty. This is the Attorney Patrick Smith Show. And if you want to write the number down for next week, 877-943-9673. Email me, patrick@attorneypatricksmith.com, or give me a call at the office during the week, 877-754-6764. God bless, and hope to see you at Cold Park.
The preceding was